My goodness, there's more people logging on than I know what to do with. Whoa, more. Hello, you guys. Good morning. I'm just letting everybody into the room, or I should say good afternoon. Want to see if there's anything in particular you guys want to talk about today. I figure the end of the month next week, we can get into emotional support animals. I know that's a big thing for everybody. So we will definitely get into more about emotional support animals. So unless you guys have something to talk about, I'm going to throw in a couple of questions I had yesterday in regards to people accepting Section 8. Sometimes they have a voucher letter. Think of that voucher letter as like a pre-approval for a loan, okay? If it says they're pre-approved for a house for $350,000 and they find a house for $250,000, that letter just says they're pre-approved for that amount. It doesn't mean that they have to spend that amount. So obviously Section 8 would make an adjustment. Let me give you an example. Your rent's $1,500 a month and they have a Section 8 voucher for $2,000 a month. That doesn't mean they're going to pay you $2,000 a month. It means they have enough money to cover what you're asking. Okay, so keep that in mind when they come to you and approach you with a voucher. Also, when qualifying an applicant that has Section 8 housing, remember it's on their portion. So if the rent at your unit is $1,500 a month and they have a Section 8 voucher for $1,800 a month, and their portion of what they have to pay is $12, then they have to have a job that makes 12 3 times a month. They have to cover their portion of what they make. So if their portion's $179 a month and they have a job and they make more than $600 a month, they're income qualified. Okay. So the making 3 times the amount is on their portion. Everybody got that? I'm trying to be helpful here. It's not on the full amount. Somebody on Section 8 does not have, and let's say your rent's let's say it's $2,000 a month and you require that they make 3 times the amount. That doesn't mean that somebody on Section 8 has to make $6 grand a month, okay? If they were making $6 grand a month, it probably wouldn't qualify for Section 8. So I'm hoping that that makes sense to you and it sticks. Remember, we can't discriminate against Section 8, so we have to participate in the program. A good choice of words, if you're asked if you accept Section 8, is of course we do. All residents must meet our criteria, or all applicants must meet our criteria. That's where your loophole is now. It's not that we don't participate in the program. Unfortunately, that's now considered discrimination against your source of income. So now we use different verbiage of, yes, all applicants must meet our criteria, or whatever your restrictions are. Qualification terms, if you will. Anybody have anything they want to discuss or talk about? I know applying for the money was quite challenging back on the 15th. Sorry, life happened to me that day, so I was MIA. Didn't mean to be. Unfortunately, we can't control when we lose a loved one. So sorry that I wasn't there to walk you through. I know April jumped on and stepped in and helped. How do you unmute yourself? See the button in the bottom left corner maybe that says mute? There's another one that says stop video, another one that says participants. If you click the mute button, it should unmute you. Did it work? I hear someone. And I'm letting people in still, you guys. People are still logging on, so.
Patty, I just want to clarify something you mentioned about Section 8, if I may.
Sure, of course.
If your rent is, let's say, $1,500 and they qualify for $2,000, they do not automatically give you the 1,500. They have a sheet that explain each sub-market how much the maximum they pay is.
Correct.
Yes, exactly. So it's
Correct,
not-
but what I'm trying to tell our landlords is if they have a pre-approval letter or a voucher for $2,000 and your rent is $1,200, it doesn't mean you're gonna be able to collect the difference. You don't get $2,000 every month. That's not how that works. That's what I'm trying to explain to landlords. J Tour, did you figure out how to unmute yourself? I sent a 3-day notice. I can't unmute. I have to unmute you. Okay, I'll go try to figure that out. But let me answer Mark's question why I try to figure that out. I sent a 3-day notice to perform or quit 2 times and just received a message from the tenant that they do not intend to comply. He states that I'm being petty. If you don't mind me asking, oh, Mark, in regards to his new car and taking up 2 spaces, you're not being petty, you're following the rules. And if you do for him, you have to do for everybody. So at this point, Mark, I would contact your legal counsel and ask them how many curable breach of covenants you need before you can start an eviction based on failure to comply. Because if you allow them to do it, you have to allow everyone to do it. And I think that I would respond to him saying that you're being petty and letting him know, no, you can't discriminate. If you allow him to do it, you have to allow everybody to do it. So give him an example. So for example, the tenant below you is going to park in that space for the next 2 weeks. And then I have to give everybody a turn parking in that space for the next 2 weeks. So just let him know, according to fair housing, I have to treat all of you the same. And unfortunately, you don't have any special privileges here. You're all equal. So the answer is no, you cannot park there and you are in violation of your contract. If I have to evict you, I will. But I can't let everybody park there. Therefore, you don't get to be special. So I just take that approach with that one. And then I'm going to go try to unmute people. I don't know if I'm going to have any luck. Wish me luck. Let's see if I can figure this out. Oh, I can. Okay. J Tour, I'm unmuting you, or I'm going to try. Nope, I can't. Participants. Hold on. I'm trying. Oh, maybe this is where I do it. Hold on. Okay, I did it. I'm going to ask you guys all to unmute and you can mute yourselves as you need to. Bear with me. I'm still going down the list. There's a few of us in here today. And then just mute yourself and unmute yourself as needed.
Can I be heard?
I can hear somebody.
This is Mark.
Okay, we can barely hear you, or at least I can barely hear you. What's up, Mark?
So you're saying that I can evict him based upon him not complying then, right?
Have they been behind at all during the COVID pandemic with rent?
No.
Okay, therefore it wouldn't be retaliation for non-payment of rent. So you most likely and most absolutely can pursue on the nuisance or failure to comply with the lease contract. Absolutely. Contact your legal counsel.
So would your firm handle this?
Fast evictions could most definitely handle that, and they'll be able to tell you how many times you need to serve that curable before we serve the quit notice in order for it to have enough teeth. I'll give you an example. LA County right now wants 4 curable breach of covenants before you do a quit, according to legal counsel. Whereas in San Bernardino County, you're looking at 1 and done. Riverside County, you may need 2 or 3. Again, this is something you always want to call your legal counsel about before you serve that notice to quit. That way you know you have enough teeth when you get into the courtroom. And the reason that I say that you should be asking your legal counsel, just so we're all on the same page, they're in there every day. That's their job. They know how many it takes. They know what it needs to make have enough teeth for that judge to most likely side in your favor. So this is when you want your legal counsel. You need their expertise. Just tell us how many it would require. So definitely give them a ring and see exactly how many. And I would strongly suggest and most likely recommend that when it comes time to serving the 3-day notice to quit, you ask them to do that part, just because it needs to be very specific. Newsflash, I don't write my own 3-day notices to quit. I have my legal counsel do that for me because they're the ones, once it's on that quit notice, that's all they can argue in court. So if they have reasons as to why they're doing these things, if it's not on the notice, it didn't happen. So it gives the attorney the tools and it's written in the language they understand. So I always have them do the 3-day quit just to be extra safe and make sure that I didn't mess anything up. How about when Section 8 changes the tenant's portion after the first year, say from 125 to 450 upon recertification? Can a landlord now disqualify a tenant for fear the tenant can't pay the increased portion? No, they're already living in the property. Where you can do that is with a tax credit property, okay? So a tax credit property. The reason Section 8 is making their payment more is they're making more. Okay, so they should be able to offset that expense or that increase. And this has to do honestly with taxpayers and them allocating those Section 8 payments properly based on source of income. So in the event the tenant got a raise, they got a new job, whatever happened, it just helps keep them qualified. Somebody needs to mute themselves. Let me figure out. Who do we hear right now? Okay, anybody have any questions? I picked that up too. April, I was trying. Does anybody have any questions? We talked about Section 8 and we're definitely talking about the other things. And I'm letting more people in as we go along here. So most definitely with Section 8, you want to make sure that you're not discriminating against source of income. In the event that that tenant does in fact get a MAP increase letter, basically that their portion is changing, you need to be mindful of that and watch that because their portion changes as well. So that you can keep on top of it. Do you have to cross qualify them? No, that's Section 8's job. Okay. So when their money amount changes, just know that you're getting a different amount. That's your job. Your job is to keep track of how much they're supposed to pay. And when they don't pay, make sure that you're giving them proper notification and notifying their worker. Anytime that tenant gets a notice, that worker's supposed to get the same notice. And help me help you, you guys. Here's one right out of my arsenal of tips and tricks. When you have an applicant applying from you from Section 8, you as a landlord have a right to see what's in their Section 8 folder. So if the landlord before you has done their job and every time they've served a notice to the tenant, they've also served a notice to the worker, it should be in that file. So when you're screening a Section 8 applicant, that's something you can call and ask their worker for. How many times were they served a notice? They might just tell you. You might be shocked at what information that worker discloses to you. So utilize that. It's definitely something that you have in your arsenal, okay? You're welcome. Okay, hold on, I see a question. Can I ask for an increase in security deposit when the tenant payment increases? You can ask for a rental increase in the security deposit when you increase the rent annually. That is when you can do your thing. So if you're under a rent control whether it be statewide or a city rent control ordinance, you can only increase the rent once annually, and it's by that allotted amount. You can increase the deposit by that allotted amount as well. Example, City of LA says you can only increase 3% annually. You do a 3% increase to the tenant on the rent and a 3% increase on the security deposit. See how that worked? So yes, you can do that. I strongly recommend it if you're in a rent control area. It is why some people's rent is $400 or some people's rent's $1,200 and their deposit is $400 because they've lived there so long. The problem is the management in front of you didn't increase the deposit as the rent was increased. So if you're doing an annual rent increase, you want to do an annual deposit increase too. It's just good business. And if they don't pay it, it's a violation of the contract. So that helps tremendously. Jay, I think I am unmuted. Can you hear me? Okay, let me go look, Jay. You are unmuted. Turn up your volume. We can't hear you, Jay. Not at all. Does anybody have anything else they want to discuss, ask questions about?
May I, Patty? I have a question.
I hear David.
Look, I have a long time ago, I inherited a building that had no lease or any rental agreement. They are all, as of now, still on verbal. How can I possibly change this into written agreement?
What county are you in?
Los Angeles.
Commercial business?
No, residential.
You're in LA County. Are you in a city where rent control governs you?
Yes, it's in Van Nuys or North Hills area.
You need to contact your legal counsel and ask them what you're allowed to do and what you're not allowed to do. There are very strict restrictions in that area. I'll tell you this, in San Bernardino County, I would tell a landlord that you can, and this doesn't apply for everywhere. Remember, what governs you has teeth. So you need to find out from your legal counsel, either that or I need to do some research, one or the other. But what I do in San Bernardino County is I give them a copy of a new rental contract with like terms. Has to have like terms. You can't do a rent increase or a bunch of increases at the time. It's just got to be like terms. And what I do is it's all in the approach, because you want them to sign and agree to it. That's the whole thing, is just tell them, hey, I was reviewing your contract and there's a lot of new laws and a lot of new protections that aren't in your old contract or you're not covered for in an oral agreement. And I just want to make sure that we have it in writing so that you know what all your rights are. Okay,
I remember months ago, you told me that you know there is a way to do this.
Yes,
to a law office or something.
I was about to tell you the way.
Okay.
So let me give you an example. In San Bernardino County, and why I keep going there is I know that's my safe county and I know I can do this there, whereas in LA County, the rules vary by municipality. So in San Bernardino County, if I had an oral contract with a tenant and I wanted to make it a verbal contract, I'd give them a copy of this lease and encourage them orally to sign it. Hey, you know, there's more protections for you in this contract than there are in no contract. So I'm trying to protect you and make sure you know what your rights are. If you approach them that way, they just might sign it. If they don't, in San Bernardino County, another thing that you can do is once they're on a month-to-month, you can give them a 30-day notice to change of terms of tenancy, and the change is the attached written rental agreement. See how that worked? But that goes county by county. You guys got to be careful. Again, I gave you a safe county that you can do that in. If it's anywhere else, I'm going to strongly recommend that you speak to your legal counsel over what the restrictions are for the municipalities that govern you. In other words, is the city say that that's okay? All right, let me see. It looks like we have another question down at the bottom. Your volume's up. Jay, I don't know. Let me try to unmute you again, okay? Let me try, Jay. I've tried. I don't know. If anybody can't talk and they want to, send me a message down here and let me know. I don't know. I'll have to ask my web guy. I have no idea. I'm sorry. Can you type your question, Jay? Okay. And, oh, Mark has a question. Hang on. Let's see what this is. When the time comes, what is the maximum increase that can be done in San Bernardino? That depends if you are subject to the statewide rent control or not. I have a cat that's coming onto my lap. Sorry. And he's leaving. I apologize. It was a sneak cat attack. Sorry, squirrel, totally lost it. Let me go back and look at the question again because I lost it. When the time comes, what's the maximum increase you can do in San Bernardino County? It depends on whether or not you're governed by the State Assembly Bill 1482, which would be the statewide rent control. If you are exempt from statewide rent control, I'm going to give you the best business practice, okay? And what I mean by that is I've always told people if you do it Widget's way, you're most likely to stay out of trouble. You're most likely to stay out of court. You're most likely to stay out of litigation. None of us want to invite lawsuits to the door. Ding dong, here comes another one. We don't want that, okay? So the best business practice and the best way that you could ethically protect yourself is going to be to wait to January 1st of 2022 before you do anything. That would mean that if the pandemic ends as it's supposed to, and I firmly believe it's going to, on the 30th of June, it would be 6 months after that before we increased rents, terminated tenancy without cause, or any of those things, and they couldn't say it's retaliatory. What is that date? January 1st, 2022. That is the drop dead date where they can't possibly say they retaliated on me and increased the rents or told me to get out after a global pandemic, and that's retaliation. So waiting 180 days after the pandemic is considered to be over with, is the best business practice. It is the best way for you to be ethical, legal, all of it, moral, you name it, okay? So I know a lot of people are like, well, what are you talking about? Remember this, I can't give you legal advice. I'm not an attorney. I can tell you what the best business practice is. See how that worked? So if you want a specific date you can increase rent, talk to your landlord. Or I'm sorry, talk to your legal counsel, not your landlord. That would be you. Remember? Sorry. Here's what I could tell you. And this is me talking to you on keeping that landlord-tenant balance in shape so that I got you on the money, Mark, and I'll get there, okay? I'll get to the money part. But hear me out, you guys. If you have a tenant that has paid you on time through the entire pandemic, okay? You never had to serve a notice. They've always paid their rent on time. And yeah, they've been a little persnickety here and there, but haven't we all? I mean, come on. This pandemic has not been an easy thing to maneuver through. But if we have a tenant that's paid us on time throughout the entire process of COVID-19, we're going to reward them by increasing their rent as soon as we can. Not a very nice way to say thank you. Do you hear me? Are you paying attention? Is this thing on? I'm just saying, if somebody has paid you through the entire amount of pandemic on time, okay, you shouldn't thank them by increasing their rent as soon as you're allowed to. That just doesn't make good business sense. It doesn't keep that landlord-tenant balance in balance. You hearing me? Is what I'm saying making sense? If they have paid you on time through the entire pandemic and haven't made your life miserable, okay, you may not want to increase rents right away. If you're under market value, I'm going to tell you the safest time for you to raise rents is 6 months after the pandemic's over. Remember, during the pandemic, we can't increase rents. We can have no additional expenses to the tenant. I understand the cost of living is going up. I understand everything's going up. I get it. I understand. But again, I would ask your legal counsel when you can increase rents. You may be able to do it as soon as July 1st of serving that notice, but it's got a lot of moving parts behind it for it not to be considered retaliatory. In other words, has your tenant paid the rent on time throughout the entire pandemic and not been affected by it? Then you most likely can increase rents on July 1st. As far as the amount, it depends on whether or not you have statewide rent control. Statewide rent control limits you to 5% plus the CPI. CPI varies by area. So I could safely say that in San Bernardino County, if you have AB 1482 and you're subject to rent control, that you want to be at 7%. If you don't have statewide rent control and you're not governed by AB 1482, currently we're in a state of emergency. Therefore, California's Penal Code 396 subparagraph B then governs you that you can increase rents over 10% while we're in a state of emergency or up to 30 days after that state of emergency has been removed. Okay, so 30 days after a state of emergency, currently we're in a state of emergency, just so everybody knows, global pandemic, it protects victims of whatever the state of emergency is. We're all victims, guys, okay? Just saying. We've all had to buy masks and stand in line and be limited on what we can and can't do. So affected is a big, broad term. It gets argued by attorneys often, okay? Either way. So be careful with that. As far as increasing rents after the state of emergency is lifted, and just so you guys know, if you increase rents 10% or higher during a state of emergency, you're looking at jail time. That's 6 months in jail and fines up to $10,000 per incident. So you want to make sure, I don't look good in orange, just saying, that you're not increasing during a state of emergency, because that one comes with a jail sentence and nobody needs that. After the pandemic's over, no rent control. Anything that's 10% or less requires a 30-day notice. Anything 11% to 14% requires a 90-day notice. They've taken away our 60-day notice on rent increases, you guys. So it's a 90-day notice if you want to increase from 10 to 14%, and anything 15% or higher requires a 120-day notice. Just so that we got all of how much you can raise, how you can raise, and when you can raise and why. There you have it. Okay, let me go back and see what other questions we have, because I'm sure we got more. Has anyone applied to the program Housing at Key received any feedback or response? We'll let April answer that because she spent quite a bit of time dealing with that. I have a house, Section 8 with management company. Tenant has some unauthorized person. Manager went today to inspect with notice. Some repairs brought up question of the unauthorized person. Tenant, she bursted at him. You are a racist because I am this color and you are that color and you're harassing me. The manager backed out and came back. The manager's going to talk to Section 8. What can be done? It's difficult to prove that the person lives over there. Serve her a 3-day curable breach of covenant and make sure it also goes to her worker and tell her, look, you can't have an unauthorized occupant in the property. Unfortunately, that's something they're going to cancel your Section 8 over. Just saying. So definitely something you want to bring to her attention. Serve her that covenant notice. Make sure you put dates, times, and witnesses. Who witnessed it, what they saw. Dates, times, and witnesses on a covenant notice is a requirement, you guys. So when you're doing that 3-day curable breach of covenant, date, time, and the witness must be on the notice for it to be valid. CPI in San Bernardino is 2%. I think it's 2.2% or 2.4%. You'd have to go look it up, Mark. I'm not exactly sure. April, here's our update. Nothing yet. They said it could be several weeks before we hear anything. The tenants need to complete the application as well. So check with them to see if they have done so. Let me say this about getting your tenants to apply for that money, you guys, and please pay attention to every damn thing that's coming out of my mouth right now. Tenant, this is your opportunity to have all of the rent due from COVID erased from existence. You won't owe it. You need to apply for this because the government is going to give me 80% of what's past due, and I'm going to forgive the other 20%, and that's going to give you a clean slate. So on July 1st, you're going to owe July's rent. And on July 2nd, if the rent hasn't been paid yet, I'm going to serve a 3-day notice to pay rent or quit right away because we're back to business as normal. Okay? No more protection there. We have kind of a protection retaliatory period, but business as normal July 1st. You don't have the rent July 2nd, serve your 3-day notice. Please take note, you guys, that if your rent is due on the 1st and you have a grace period till the 5th, that has to do with when your late fee is applied to your account, not when your rent is due. You can legally serve a notice to pay rent or quit on the 2nd if your rent is due on the 1st. It all has to do with when that day falls in the week. Remember, there has to be a full business day to pay the rent before it's delinquent. Example, rent's due on the 1st. 1st is a Saturday, not due yet. Here comes the 2nd, it's a Sunday, not due yet. Here comes the 3rd, unfortunately, it's a holiday, still not due yet. Rent's due on the 4th, delinquent on the 5th. So you can't even serve a notice till the 5th of the month in that particular scenario. So watch what day of the week, and I've already looked on a calendar. July 1st is not a weekend or a holiday. So rent is due on the 1st, delinquent on the 2nd, just so everybody remembers that part. And I saw a couple more questions come by. If our property is in LA under LARSO, when can I raise the rent after the emergency is called off? It's too soon for me to answer that, but I could tell you safely, you can increase the rent without them being able to cry retaliatory or sue you or anything on July 1st of 2022. I know it's not the answer you wanted to hear, but remember, there's a lot of moving parts. Can you increase the rent? Most likely, if they haven't been delinquent at all during the pandemic period. But then my question to you becomes, is that how you're going to thank them? Because that doesn't keep your landlord-tenant balance right either. Just saying.
Patty, just 1 second.
You got it.
Los Angeles has only 3% rent increase. And if you're increasing everybody by 3%, how could that be retaliatory for the 3%, everybody across the board?
Because how are you increasing rents after a global pandemic and not allowing 180 days recovery time?
I don't know what to say.
I know. I need you to get in the mind frame of fair housing. Okay. Fair housing says right now in current law, if we have a tenant that calls code enforcement that finds a violation at our property, and I mean, a violation could even be an address number, not on the property. Okay. We can't do anything to them for 6 months or it's considered retaliatory. We can't terminate their tenancy without cause, and we can't increase their rent for 6 months. Same thing happens if they have bed bugs. We can't increase their rent or terminate their tenancy without cause for 6 months, or it's considered retaliation. Same thing happens if they call code enforcement, fair housing, health and safety. What do you think a global pandemic is going to do? In other words, I don't have that answer yet. But looking at the history of fair housing, I can almost tell you that a global pandemic is going to offer some sort of protections. Have you seen the retaliatory issues in Senate Bill 91? They're no joke. That leads me to believe that they're going to extend the period for retaliation for 6 months, but they are going to throw some loopholes in there. And some people are going to challenge those loopholes. Here's my thing. Do you want to be in a case law situation?
But that lady increased it by 200%. You talk about only 3%.
I understand that, but that lady was dealing with a fire. We're dealing with a global pandemic. I don't know. In other words, I can't answer your question. My goal is to have you guys err on the side of caution and not invite lawsuits to your front door. With that being said, I'm going to again tell you the safest time for you to increase rents is January 1st. Okay, hold on. I got more questions coming across. Again, talk to your legal counsel. Call fair housing. It's not against you as a landlord to call fair housing and ask their opinion. See what they tell you. We have the right to see the tenant file. Who do we contact? Okay, Jay, I got your attention with my Section 8 tip and trick. As a landlord, you have a right. They sign saying that you can check their past history with previous landlords. Talk to their worker. Ask to see what notices are in their file. This would be with their Section 8 worker. You can call them and ask them questions too. Have they ever been served a 3-day notice to pay rent or quit? Have they ever been asked to leave a property, and what was the reason on the notice? Has an eviction ever been started? I mean, ask their worker. Their worker can be interviewed just like a previous landlord. They used to, and I don't know that they'll do it anymore. They used to say, come on down here. We'd be more than happy to show you the file. But I'm talking about 15 years ago.
I had a case like this. I talked to the caseworker. She was very cooperative. On the phone, she gave me everything, exactly like what you said.
Okay, thank you so much, David, for piping in and having my back, because that's what we are here. We're a big support group for each other, you guys. If you got a tip and a trick that will help somebody, speak up. So in my case, and I'm speaking to you, Mark. Oh, wait. I got to go way back. Who is going to watch out for the owner? In what incident? Joy, I don't know what you're talking about. Who's going to watch out for the owner? Fair housing is going to tell us when we can increase rents and it not be retaliatory. We haven't heard from them yet. So I have a big feeling we're going to hear from them. So definitely want to be careful with that. Let me go to Mark's question. So in my case, if code enforcement is involved from here, would it be retaliatory? Code enforcement is cause. So the answer to that question is no. Code enforcement is cause. Why are you being evicted? Cause you violated code enforcement's rules and regulations. Make sense? That's a cause case. No cause would be, I want my house back. See how that worked? So you have cause, a different set of facts. Graylin, when applying for the Housing is Key program money, will the program pay off back rent owed leading to March 2020? No, it covers from March 2020 through June of 2021. Any previous balance, it does not touch. Anyone get the rent relief program money yet? Joy, I hate to tell you this, but my opinion is you're going to see that money probably in the month of June. It's not going to happen quickly. You have to apply, tenant has to apply, and then the government has to issue a check. They don't do anything in a rapid fashion. Just saying. I think it's apply in March. So maybe by May or June, we can get our ducks together and get you a check. That's how I see it. But what do I know? Just a blonde. But I don't think that money is going to come fast, super fast. They're paying you through the month of June. So if you applied now in March and the tenant applies in April, that gives them till May to give you the check all the way through June. So my anticipation is that money's not going to come quickly, but that money is going to come. Does anybody else have any questions? For those of you doing dispositions of security deposits on tenants that are voluntarily vacating or vacating due to an eviction, please take note. You cannot put any rents owed during the pandemic period on your disposition of security deposit unless the tenant says it's okay. And you have to get that in writing that you can deduct past due rents from their security deposit. Otherwise, you cannot take any rents during the pandemic period out of the tenant's security deposit. You can only sue them in small claims court, but not until August 1st. Okay, so in the event your tenant owes 6 months of rent that happened during the pandemic and they vacate right now, and they leave that house immaculate with no utility bills left behind, you cannot take the rent that's owed to you out of that deposit money. Okay, you have to refund the deposit and sue them in small claims court in August for the money that's owed to you. Why I get asked this all the time is the government says that that money is no longer considered past due rent. It is considered consumer debt, and you can only enforce the repayment of that in small claims court. So just a reminder, you guys, if you have somebody that moves out and they owe any rent during the pandemic period, even their last months, you can't deduct it from their deposit. Okay? Please don't forget that one. It comes with fines, fees, and retaliatory issues as well. There's a lot of retaliation things that have been put on here. Okay, hold on. Where was there a law made prior to the pandemic about evictions not being reported? Yes, it was called the eviction masking law, passed January 1st of either 2017 or 2018, but you can look it up. It's called the eviction masking law. And basically what it says in simple English is that from the date that a court case is filed for an eviction, if the tenant, and this is the most bass-ackwards law ever written, okay? And just hear me out. What it says is that from the date of the filing of the eviction with the courthouse to the date where a judgment's been made, if that is 60 days or less, then the eviction shows on the tenant's credit report. If it's 61 days or longer, the record's sealed and nobody can see the eviction. What does that say to us? That says that the tenant that goes, oh, I can't pay, boom, they get served a lawsuit and they're like, whoa, landlord's serious here, don't want to play around, I'm going to vacate. They get the eviction on their credit for going quietly into the night. And the person that fights you, rakes you over the coals, drags you through litigation, gets the record sealed and nobody gets to see what they did. It sends the wrong message to the wrong people. Everybody got that? That's what the eviction masking law does. So that guy that shows that he has an eviction on his credit report in 2019, know that he got served the paperwork and ran in the middle of the night and didn't rake that owner over the coals. That's what you can know. And the person standing in front of you going, I'd like to rent here, and no evictions are showing on their credit report, they might be the person that is extremely litigious. We used to say all the time is you never know if the person standing in front of you applying has been evicted or not. So stop putting it into your equation. You don't know. You have no way of knowing. So go through all of your other criteria and do the best that you can there and stop looking for those evictions. And if you see them, know that that's somebody that probably bailed in the middle of the night as soon as they got served with a lawsuit. I see more questions coming up. Let me get back to them. Where can I see the eviction masking law? Google it. I don't, it's been a few years, like 4 years. I don't remember the assembly bill off the top of my head, but it is called the eviction masking law. And I would just Google California eviction masking law. Do all payments made during the pandemic period have to go to pandemic rent? Graylin, are you paying attention? And please hear me out and everybody else. During the pandemic period, we can't have any rent increases, no late fees, no additional expenses to the tenant at all whatsoever through utilities or anything else. Okay, so if there was a water bill increase with a RUB system, the increase might not fly. With all that being said, here's what I can tell you. It comes with fines that range from $250 to $2,500. They could implement those daily, weekly, or monthly. It is up to the court to decide. From what I've heard so far from a couple of attorneys is if there was a rent increase done, that increase happened on a monthly basis, so that fine comes to you on a monthly basis. Ouch. Not worth it. Definitely not worth it. Let me go back and look one more time. So during the pandemic period, if they didn't pay for a couple months, they could have already paid the 25%. So what it says in Senate Bill 91 is that landlords need to keep accurate records during the pandemic period and have to apply the rents received during the rent it was received, during the month it was received. So if you got $5,000 in the month of December, that $5,000 gets applied to December and is a credit going forward. Okay. If you have to go to court for any time of rents during the pandemic, here's my opinion to you, because I can't give you advice. Handwrite a columnar ledger. Take that to the judge. It's not going to show any previous rent balances owed because you can't include them during the pandemic time. You also, if you're using an accounting software, it is automatically programmed to apply that to the most previous past due balance, which makes it extremely difficult, So just handwrite a columnar ledger for the pandemic period. It's probably much easier than going and rewriting your accounting software, because your accounting software automatically puts in a late fee. You can't do that during the pandemic. So do we want to show the late fees taken out? Do we want this? Do we want that? It's just easier if you have to go to court to handwrite a columnar ledger to take to show to the judge. Much easier. But no, to answer your question, you have to apply COVID rent monies during the month it was received during the pandemic. At this point, Joy, yes, starting July 1st, you should be able to charge a late fee. Which law says that during the pandemic, you can't increase the rent? Senate Bill 91. No additional expenses to the tenant during the pandemic period. No rent increases, no late fees, no utility increase expenses, no notice of change of terms. If you hand wrote a different payment for them to pay you, you can't charge them interest, fines, fees, or penalties on the rent they didn't pay. They can have no additional expenses to the tenant during the pandemic period. But yes, it's Senate Bill 91 that currently governs us that explains that. in one of those 47 pages. It's a long one, you guys. It's insane. All right. Does anybody have anything else? We're almost up on our hour and I don't want to bore you guys. And I feel like I'm the only one talking because I am. And I see you guys out there, but I am only talking to myself. So it does get kind of weird sometimes. Don't know what the weather's been like in California. I'm still on the East Coast. It is currently pouring rain here today, cats and dogs and cats. This cat right here is waiting for me to get off and sit back in the chair just a little bit more so he can climb up in my lap. And you can hear the other one crying in the background, I'm sure. So if nobody has anything else, I'll go ahead and end for today. I appreciate you guys more than you know. I'm glad that I'm able to answer questions. It keeps me on my toes, and I appreciate that from you. Next week, we're going to do our hour lunch and learn on emotional support animals, what those rules are, what happens when you break those rules, and what you're up against. So you might want to keep in tune for that. I'm going to give you guys my tips and tricks out of my own arsenal of different ways to look at the emotional support animals so that you don't have costly mistakes. Fair Housing sees emotional support animal cases to the extent of this much. It's the ADA that sees all the rest of it. So that's the American Disabilities Act and not something you want to mess with. So we're going to talk about different ways to make sure that you're protected under both Fair Housing and the ADA and HUD. We don't want to get involved in a HUD case over an emotional support animal. And we're going to talk about who can write that doctor's note, who can write that note so that you can have an emotional support animal. That way, that's going to answer a lot of those questions. And hopefully I put that in perspective so that it resonates and sticks with you guys. I'm also going to give you my tricks of how I look at emotional support animals because it answers a lot of my questions right out of the gate. And then I don't have those questions anymore. So very important that we address these things as they evolve. Emotional support animals, and I believe at the end of April, we're going to do a class on mold. I'm seeing more mold cases come about. They seem to go in waves. Lead-based paint cases, same thing, they go in waves. So right now I'm seeing a trend of more and more mold cases. Might have to do with the weather, might have to do with global warming, I don't know. But I do try to notify you guys when I start to see trends coming about, and that's definitely one of them. Also, when you're advertising, you guys, please, I beg you, don't pull an old ad to re-rent a new house. Do not pull an old ad to re-rent a new house. Everybody understand what I'm trying to tell you? If you are the person that goes, well, let me pull the ad up from 4 years ago and I'll just reuse that ad, that's how you're getting busted for no Section 8. And mind you, it's only 5 letters, NO space SC8. Well, I guess it's more than 5 letters, but it's a little tiny thing in your ad that's only like this big. People are missing that. There's people that are hungry for your money that you don't want to spend. And they want that money. And I'll tell you right now, we had somebody pay $12,000 to stay out of court in San Diego County because they accidentally printed an old ad. $12,000 to stay out of court. The person didn't even apply. They didn't even call the landlord. They just saw the ad. Okay. So very, very careful. Don't use an old ad to re-rent a new vacancy. Don't do it. That's where the mistake's being made. We used to be able to cut corners doing that. This isn't a corner you want to cut, not for 12 grand. It's not worth it. All right, you guys have a great week and a great weekend. I will see you on Wednesday. We're going to talk about emotional support animals. Somebody sent me an email with forms I wanted for ESA. Did you have a chance to read it? I will look at that. Send it to me again. Remember this. You can't have any rules. Can't have any rules. The city can have rules. The county can have rules. You can't. So what you want that verbiage to read is we have to follow the city's guidelines here, and they only allow 2 dogs and 1 cat per household. You can't have any rules for the emotional support animal. Example, you can't say you must have your emotional support animal on a leash at all times, because you can't have any rules. But you can say the city requires that all dogs, and it better be the city's rule. Don't say, oh, I'm just gonna add this in here, because it will bite you, and it will bite you hard. The city requires that all dogs be leashed when outside of their dwelling. Okay, whatever the city's rule is, that's what your rules can be. City, county, state, federal. Okay, but you can't have any rules. You can't tell them they must clean up after their animal. That's a given. Their animal can't be a nuisance, whether it's pooping everywhere, barking all the time, or biting at people. It can't be a nuisance. And we'll talk more about that next week, okay? You guys have a great week, a great weekend. And if you need me, you know how to find me. Bye.